Okay, we're live streaming now, and we're waiting on one person, Megan Taylor, who I think she was having trouble joining. All right. And so we'll get started. Welcome to our March community conversation, Keeping Families Together, Pretrial Justice. We are holding this discussion because Oklahoma currently has one of the highest pretrial incarceration rates in the country. This means that a significant number of legally innocent people are being held in jail for extended periods of time prior to ever even having a trial. This not only affects the conditions within our jails, but it's also a major disruptor of the lives and families of these individuals. So from pretrial risk assessment to cash bail and prolonged detention, our pretrial system is desperately in need of being reformed. So we're going to learn about this issue today. Here to help us understand what's actually happening are our guest panelists. We have Francie Ekru, who will be joining us pretty soon. She's an assistant public defender from the Federal Public Defender's Office of Western Oklahoma. Cameron Pipe, the regional director of the Bail Project. Christina Saleh, the program director of Still She Rises. Megan Taylor, the executive director of the Diversion Hub, who will also be joining us shortly, and Ryan Mukes, an advocate, as well as one of our newest OCJR ambassadors. So thank you. Hi, Francie. Thank you all for being here. We really appreciate it. You all do so much within this arena to help folks who are stuck get unstuck, as well as advocate for those who are. So we really want to tap into your expertise. So Christina, I'm going to start off with you. If you could just, give us a foundation. Can you explain to those of us who may not be familiar with this space, what exactly the pretrial system is and what takes place during this period?
Let me unmute so that you guys can actually hear me. So pretrial system, I think, is an overstatement of what's happening, right? There is a pretrial legal process, and then there's a bunch of other stuff that also happens during the same time when the legal pretrial process happens. And so pretrial, when lawyers talk about pretrial, they're talking about anything that happens from either the moment of arrest or the moment an arrest warrant is issued, all the way through to the moment of trial. And that can encompass a lot of different things legally. But when we talk about who's actually involved in the pretrial process and in the pretrial system, as Evita said, it's not just the judges, not just the prosecutors and the attorneys, but you also have people who are not officers of the court or part of the legal system, technically having a major influence on how that system works. And the people I can think of off the top of my head are the Bail Project and the bail bondsman as major stakeholders in what happens to somebody and whether or not they're spending that pretrial time incarcerated or back at home with their families as they're trying to figure out what their next steps are and how to best participate in their own defense. Then in addition to that, you have all of these, what our office calls sub-legal systems, sub-legal players that are not quite part of the formal parts of the legal process, but are either brought in or are small departments within the court system that play a role. And this could be things like pretrial services that are actually part of the court system, providing some of the same services that Cameron and the Bail Project do, or at least claiming to do that, as well as nonprofit organizations that are designed specifically to intervene, all of which with the assumption that the people who are in the pretrial process need extra help. And so the presumption of innocence is sort of overlaid with this expectation that individuals need help or on some levels, when it comes to pretrial services, are a danger or a threat. And so when I think about the system, I often think about the legal process first, but the reality is it's a much larger community of people and players who are having an impact on what an individual's experience is through that process.
Thank you for providing that foundation for us, and we're going to build on that. So this next question is for Francie. Francie, do we happen to know what percentage of criminal cases actually go to trial, and why that may be?
Okay, so thanks, Evita. I did a little bit of research and asking around on the federal side. I don't know the statistics at the state levels, but what I was seeing is, generally speaking, the states are not far behind the federal statistics, meaning the federal statistics tend to be higher, but only slightly. And so starting in 1962, 8.2% of federal criminal cases went to trial. That went down to less than 5% in 2002 and 3.6% in 2013, 2% in 2018. And so with that data trend, it would suggest that it's down even more today in 2023. The filings have gone up some, meaning 80,000 criminal, there were 80,000 federal prosecutions in 2018, and in 2022, there were about 122,000. So they've gone up, but the percentage of cases that are going to trial are still low. And that's for a number of reasons. I don't know if you want me to touch on that now.
Yeah.
It's a lot to explain, but to summarize, it's kind of really a system of criminal plea bargain versus criminal trial, meaning the trial is the exception versus the commonplace norm. I know here in the federal system, from a client standpoint, there's a fear of a partial jury. You're not really going to get an impartial jury when you go to trial in Oklahoma, whether you're in a federal system or a state system. And that scares people, especially because of the disproportionality of minority peoples that are present in our criminal legal system prosecution pools. So beyond that, at least the federal system, and it's definitely different at state, but the federal system is going above and beyond to do pretrial investigations, or actually pre-charging investigations, where the evidence against the person is stacked so greatly, not in their favor. It looks scary. People don't want to take that gamble. And if they do take the gamble, then there's the sentencing guidelines that will punish somebody up to 3 times more harshly for going to trial and losing versus accepting the plea from the start. And pleading guilty yields bonus points in the federal system, where the judges can choose to depart downward, to vary downward, and the sentencing guideline will be set at a lower suggested punishment range than it will be if the person goes to trial. And so with all those factors included, kind of just the connotation of a federal prosecution versus a state prosecution, everyone, including the person who's being accused and the jury members, think, well, if we're in federal court, they must be guilty. I must be guilty. I'm in federal court.
Yeah, or done some really bad, right?
Right. But what we know is that's just not really true. We have a lot of federal prosecutors that are dipping their hand in the state cases and bringing them out over to the federal court because they simply don't have enough cases to prosecute at the federal level. Or they kind of are perceived as that easy, low-hanging fruit that they can just grab and prosecute federally. But that puts a connotation on the case for the person accused and a potential jury that this is more serious, or this is yielding more guilt because it's in federal court versus a state court. With that said, the same factors are present in a state court. How much time you're going to have to wait in custody while you're fighting your case. That's a big deterrent in a state court setting when the county jails are not up to constitutional standard, and you're subject to extreme conditions that if you just plea out earlier, you can be out of that jail. And a lot of people, fortunately and unfortunately, are succumbing to that reality that if I just plead guilty, I can get out of this horrible jail setting and save my life, number one, but number two, save everything else involved in remaining incarcerated for long periods of time. So, with that said, the percentage of cases that are going to trial are very low. And we all can see, everyone on this call can see, that's not on accident, that's by design. And it yields this notion that the system is not, it's not broken, it's fixed, and it's fixed in this manner to stay in this manner. It becomes broken when people like ourselves on this call are challenging it and trying to do something different. That's when the criminal legal system perceives itself to be broken and needing help, because the status quo is being challenged and we're finding ways to overcome it or change it, whether it's through legislation or through sentencing policy or the nonprofit local levels, or the specific offices that we all work in that are doing something to change this.
Yeah, thank you so much. I know the statistics sound good, like, oh, that's promising at first, but when we realize that it's because of the amount of plea deals that are given and the process that goes into that, then we realize that this is still a jaded system, right? Well, you did mention that, people being held, detained for large amounts of time. So we know that they're held for extended periods of time while waiting for their trial. And like, how long generally does it take to go from an arrest to trial, typically for a felony case? And this can go to Megan or Francie or any other lawyers on here. And what is the average length of stay, as well as the longest length of time that you've seen someone be detained pre-trial? I would like to chime in.
I'll let Megan touch on the state system. In the federal system, it could just really range because it depends on the type of charge and how fast that charge can be disposed of. And then it depends on the federal system has a different pretrial release system where it's solely up to the judge. It's not cash bail. And there's a number of factors that play into that, whether the person was able to be released. But disposing of the case depends on the severity of the charge, the negotiations, the discovery, how long it takes for the discovery to be given to all parties. It can be anywhere from, I've got an illegal reentry case that was done in 2 months or less. And then we've got cases that have been pending here for 4+ years. So it's a large margin. The longest time I saw somebody in pretrial custody at the state level before coming to the federal level was 5 years. I think Mr. Ravitz at the Oklahoma County Public Defender's Office told me his longest pretrial detention was 5 years. But Megan knows that stuff much more than I do, especially now. So I'm going to pass it to her.
Yeah, just honestly piggybacking off of what Francie said, I looked yesterday on Jail Tracker to see the longest stay in Oklahoma County Jail, and it was about 3,500 days. So there's a big disparity, like Francie said. It depends. Some cases are handled quickly. Other cases are continued over the course of several years based on issues with getting discovery, based on availability in the capacity of the district attorneys to get those cases tried. Nonetheless, that's still an issue because over half of the folks that are sitting in Oklahoma County Jail have not been convicted. And so that's a significant problem because, again, we're taking them out of the community. So it's a big disparity. We see folks that have come to Diversion Up that get released on a $500 bond at a dispo docket that have been in for several months, which of course is not okay. So it really just depends on the charge and the circumstances at the courthouse.
Thank you. So help me understand this. But let me ask this question and then Ryan, because I'm going to ask you the next, you'll be the next one. But are there any assurances within our legal system that someone has a speedy trial? And if there are, why is it not working? So go ahead.
Yes, there at the federal level, I was, hit in the forehead with it because it didn't necessarily exist at the state level, but the Speedy Trial Act is taken very seriously at the federal level. At the state level, you don't necessarily have to show proof that your client approves a continuance beyond their Speedy Trial Act, their time to assert that they want to go to trial, whether it's 60 days or 70 days. At the federal level, it's absolutely taken seriously, and the client has to sign a waiver of their Speedy Trial Act deadlines and whatnot in order for an attorney to continue a matter beyond the 70-day period that they have an absolute right to go to trial within. So it's a constant thing here that we do as defense attorneys, constantly watching our clock. Where are we at with that? Because we know our federal judges are taking it seriously, and they do not like a lot of continuances. They will set the tone early as to how many continuances they are going to be inclined to grant. And that kind of lets you know how fast you need to get to work. And usually that is within, usually that is always within the 70-day period. And so I will say here, it's much more of a thing. I never really even thought about it or looked at it at the state level. So I'll let everybody else talk about that.
Some folks working on the state level, any ideas?
Well, so Oklahoma County, when I was in the DA's office, I only had maybe less than a handful of defense attorneys file violations on speedy trial. And it is kind of the wild, wild west in the sense that, like Francie said, it's not really something that's taken very seriously at the state level, which is obviously concerning. We've got a lot of folks in the system that believe that waiving that right protects them down the road for any subsequent kind of speedy trial violations. We've got a client right now that's been out since 2018, and to try to get this case closed and to try to prevent further continuances has just been a total and complete nightmare, because again, there really isn't a consensus at the courthouse that it's something that we should be making sure that we're preserving for the clients. So Christina, I know you all in Tulsa, I would love to hear if it's a different landscape, but for the most part, Oklahoma County just does not think it's a fundamental right, which is not how we should be functioning.
Yeah, it's the same in Tulsa County, but I think I want to highlight the fact that we think about it in terms of the law, and there are on the books speedy trial rights that our clients have that aren't necessarily put into effect. But some of the structural ways that our courts are set up are meant to the entire system is meant to work for the convenience of the courts. And so if you think about the fact that there are only certain weeks out of the year that are considered jury weeks, so there are almost half of the weeks in the year, you can't get a jury trial in Tulsa County because there are no jurors. And that's based on, and that's built in, and everybody's expectation is that is normal, and that is part of the process. And so that adds weeks and weeks and weeks and weeks and weeks to people's timeline of being enmeshed in this system. And then when you think about what are permissive reasons to push the case out or to set a particular date, you're looking at the court's timeline, you're looking at the attorney's vacation schedules, you're looking at the personal reasons that all the people inside the courtroom that are system players have for why they shouldn't be. And we have really struggled to advocate. Our client is pregnant, and she doesn't it is not going to be a good time for her to go to trial when she is in her third trimester. And we can be successful, but you have to fight. Somebody has to raise those issues, and it is not a part of just baked into the system the way that all of these other sort of less significant but more accepted reasons for scheduling are set up. And so I just wanted to highlight the fact that a lot of what's happening is just about the convenience and the efficiency of the court system and their process, and thinking about an individual defendant, our clients, and what's best for them goes way at the bottom. And then you haven't even gotten to the part of like, how do you explain to your client, I can't guarantee that you're going to go to trial that week, 3 months from now, but you're going to need to tell your job that you might have to be gone that whole week and try and keep your job. And at the last minute, that a whole plan could change depending on, if the prosecutor is not wants to prioritize another case.
Yeah, thank you. And so we've been talking about how inherent in this conversation is how it's harming the clients, the individuals, and potentially harming their families. And we see that, especially when we're talking about prolonged detention, how that can really harm individuals and their families. And what are some other challenges that you've experienced or seen your clients experience because of this? Ryan, I'm going to start with you. Help us understand.
Okay, well, I would like to start by saying that I feel like the pretrial system is set up. All these things you guys are saying may have a little bit to do with it all. But from my perspective, the pretrial system and why they don't want to give you a speedy trial, for one reason, is they want you, if you're released, they're probably looking for you to catch another case. So therefore, that would ensure that you're going to sign for time, because there's no way you're going to be going to trial while you're fighting another case. And I know that for sure because my attorney informed me both times I was out, don't catch another case or there's nothing I can do for you. So first of all, I would like to state that. Second of all, there's the buddy system. We all know that district attorneys and attorneys, a lot of them go to school together here in the state of Oklahoma. So I feel like it's a money thing. Like, okay, well, if we can get him to file this motion and I can charge him an extra $5,000 on top of the 25 that I've already done, I really do feel like, hey, well, I'll give you 2,000 or 3,000, buddy, if you just keep it. I'm not saying that's how it goes, but this is how it feels from being a part of it, because I consistently told my attorney I wanted to go to trial because the last case I caught, I felt like all my rights were violated. Well, keep in mind that my attorney agreed with me, but he also agreed that that's going to be hard to get these motions and file against the DA that works with the judges. And, so the whole pretrial system is set up to basically add pressure to someone who's already more pressure to someone who's already in a bad situation, which would trickle down to when you do have time with your family and friends, you're so overwhelmed and stressed that it's hard to maintain focus and energy to give to them. Or when you go to work, all you're thinking about is how you need to make this money to pay your attorney to stay out. There's so many different little bitty nuances that goes on in pretrial that I feel like is a whole manipulation that the system uses against just something that's the system has a overwhelming effect on the clients that they just use to manipulate the whole thing as far as pretrial.
Thank you, Ryan. So, and Christina and Megan, what other repercussions, have you seen families, divided or separated, or, what have you seen people incur as a result of maybe being detained for 5 years or, 3,000 days or whatever it may be?
I want to highlight one thing that's a whole other legal case, and then we can talk about the real life stuff. Maybe Megan can talk a little bit about that. Our office practices in both criminal court and on the juvenile deprived docket here in town. And speaking of speedy trial rights, the laws on the books require a parent to go to trial on their deprived matter about whether or not they're going to have their child in their custody, and sometimes whether or not their parental rights will get terminated, often before the criminal case will get resolved. And so any kind of presumption of innocence, the issues with incriminating yourself because you may be forced to testify in that trial if you exercise your right, And then the question of whether or not you can take a quick plea to get out of jail so that you can show up in this other courtroom and fight for your kids is a real battle that our clients face. And so that is why our priority is getting them out every time so that we can figure out a way with them to create a strategy for both cases that prioritizes what they want, which is very often just to be with their children.
So we regularly see clients that end up losing housing based on being detained in Oklahoma County Jail pre-conviction. We see folks that are losing their jobs, they're losing custody and visitation rights of their children. I mean, any stabilizing kind of area in someone's life is quickly pulled from within under them when they are back in custody. And so, but the biggest and the strongest piece that we've seen is the housing component, because it is so tricky. So, you know, one specific example, we had worked for years to get a voucher under Section 8 for a client. This was a case that the prosecutor had filed after several months of the initial arrest. And we were looking at, you know, years being on the pretrial docket. We finally got housing, we got a voucher, we got inspection. This was the first time that this client was ever going to have their own home and have a safe environment to go. And we advocated with the housing team, we advocated to the district attorney. It didn't matter. It didn't change the course of what the state was recommending, and that was prison. And he's out now. We were able to maintain housing while he was in custody, but that's a unique situation. Most of the time they lose that. And then when they get out, they have an additional hurdle that they didn't have prior to that. That's really out of their control at that point. So there are a lot of destabilizing factors, but that's just kind of one specific area that we're constantly trying to kind of finesse when folks do get pulled into the system.
And that just makes it all worse. Right? So you probably went from 1 to 1,000 after that. Oh, Francie, we're going to say something.
Yeah, I was hearing what people were saying. Sorry, and forgive. I took a call from a client because I just know they were going to keep calling. So y'all forgive me. And I've heard some. So if I'm repetitive, these are just things I jotted down. You lose your housing, your job, your custody of your children, any schooling that you were in, or potentially the schooling of your children or dependents, your basic needs, your food, your water, you know, the utilities at your home, your driver's license, your any type of treatment you were in, or efforts towards your sobriety. And then specifically lately, I've got a situation where my client was the sole caretaker of her children. And accordingly, they've had to go into DHS custody, but she had doctor appointments for them coming up regarding speech therapy and appointments to consider the spectrum, the autistic spectrum for one of her children, things like that. And now there's nobody really to go fulfill those appointments. They have gone into DHS custody, and those appointments have been set off for another year. So her children are not going to be seen for those medical and treatment considerations that they need now. She was days away from taking them to those appointments, but they're set off for another year and tagged as non-life threatening. But those are actually, in my opinion, life-threatening, because those are situations in which if they've got attention on those matters now, their life, the trajectory of their next year is changed. So that's just something that I jotted down when I saw your question, Evita, and wanted to point out that it's very much a domino effect, and it spills all the way down into every piece and every fabric of a child's life or a dependent's life. Otherwise, I've got some clients that take care of their grandparents or their parents, and now those people don't have anyone to care for them, and DHS gets involved, and the cycle and the story kind of continues. So just wanted to point those out.
Yeah, thank you. And can have generational effects, right? I want to move now, talk more about bail and pretrial release. And Cameron, this is predominantly your work. So like, first of all, what are the factors that go into deciding someone's bail or whether or not they are, that's even an option?
So there's many options that go into determining whether or not someone's going to be eligible for cash bail. And I definitely default to the attorneys on the call that are arguing on these matters each and every day. But some of the more common ones that judges are considering are a person's, previous criminal history. Are they a flight risk, right? Will they return back to court or not? Do they have ties in the community to feel as if they're going to be stable once they get out? Maybe taking into consideration what their current path towards sobriety or what active addiction they may be in at a current time. Are they experiencing a substance use disorder? There's a lot of factors that go into that. And typically kind of the largest overarching one is dangerousness to the community and whether or not this person may end up causing harm to a community member or to someone else that maybe already be a part of the current case that they're pending on. But the things that we know about cash bail, a lot of those factors I mentioned really are harmful to folks that are from lower socioeconomic backgrounds due to the fact that they may lack some of that stability that judges are oftentimes looking for, right? They may not have a physical address that they're at every single night because they're actually, staying between one shelter or the other, or they may be staying with family members. They may not lack stable employment because who knows, maybe they had a previous case where they had a felony conviction and it's difficult to find work. And so because of that, they're further punished and criminalized for the lack of resources that they have.
Thank you. And can you just briefly tell us how the work of the Bail Project helps support people so they can avoid detention?
Yeah. So the Bail Project's role, really we intervene and our target intervention is kind of the day that bail is set, right? So we work in the pretrial context and do our best to serve any individual that has a cash bail set that we can actually step in and pay. Resources are not unlimited, so we tend to target and have a focus towards individuals. They're around a $5,000 bail cap and under, so that way we can work to one, step in and pay their bail for them completely free of charge. There's a really aggressive for-profit bail industry, not only in Oklahoma, but in the country as a whole. And so because of that, everyone that is a Bail Project client, they did not pay a penny for their freedom. We step in and we pay that for them. And the things that we do after that, we offer them with court reminders. So that way they know, hey, you have an upcoming court appearance next week. Do you need transportation, right? Which is the third branch of the services that we offer. We work to get folks to court however we can, whether that's taking a Greyhound bus, whether it's getting in a Lyft or an Uber. Maybe their family needs some support with finding a gas card voucher or whatever it may be, identifying what that need is and reducing those barriers. And then the kind of final leg of the Bail Project in terms of our direct service model is if a client says, hey, I'd really like some support with getting with housing or with my substance use disorder or my mental health, they get to identify those things on a voluntary basis. And then we work with them and hand them off to great organizations like the Diversion Hub in Oklahoma City, so that way they can have their needs met and they get to have an opportunity to say, and the agency to say, this is what I want support with. And it's not court ordered or mandated, and it's no condition of release whenever we pay bail for our folks.
Yeah, thank you. So really, everyone's doing great work. This is great work. I have this question. So we talked about how bail is, determined, the different factors that go in it. So this pretrial risk assessment, is it flawed? Is there some precept of, or does it threaten the precept of equal justice in some ways? There's some bias in it at times. I see some eyebrows raising.
I think there's a lot of confusion about risk of what, right? Because what it is on paper when it comes to the law is, are you going to return to court? And the reason it's limited to that is because there's a presumption of innocence. As soon as you start to expand the idea of what the risk might be, you are eating away at that presumption of innocence. But it is very easy for judges to do, because what they have in front of them is statements that police officers have made, that where police officers have guessed at what the prosecutor might charge somebody with in the future. Doesn't always work out that way, right? So they have an incentive to make that charge as serious as possible on paper, because it leads to a higher bail by default, right? In the initial bail schedule. And so they're looking for the most serious charge they can attach to somebody's name to keep everything high to begin with, and to establish a level of seriousness, even when ultimately the charges that get filed or the charges that actually stick to somebody once the probable cause determination has been made and things like that are much less serious. And so when we talk about risk of not coming back to court, right, that also has a flaw, because the entire burden is put on an individual in a town where there is very limited public transportation, where there are all of these stability issues. The first 48 hours is when everything that Megan and Francie talked about happening to an individual when they are arrested and incarcerated. That's when the destabilization happens. And so they're supposed to get out of jail, put their whole life back together, and then have everything set up and ready to go so that they come back to court at 9 a.m. to sit there and wait potentially for 2 to 4 hours for their case to get called. And so I just wanted to recenter us in this conversation about, like, what is pretrial risk? And so many of these risk assessment tools really expand beyond risk of not coming back to court and get deep into the kinds of things that we think about, like, why do we have a criminal legal system in the first place? Community safety, for deterrence. We don't want, people who are inclined to do these kinds of horrible acts that people are alleged to have done in our community. But none of that can happen by law until they have been found to be guilty. When we expand our understanding of what risk is, we pull everything back to this moment and the arrest ultimately being the conviction.
Thank you, Christina. Anyone else want to chime in? Y'all like, we agree. Okay. Oh, Ramsey.
Oh, did I skip somebody?
No, you're good. You're good.
So yeah, I agree with everything Christina's saying. That it's definitely like what our clients say, you're guilty until proven innocent. And so I've literally had, and I want to say it could potentially be written in Oklahoma statute that way, but the district attorney's office has cited over the years that I was working at the state level that you are presumed guilty for the purposes of pretrial release. And they are quick to cite that down, throw that down, and then scare the judges into keeping that person detained. In the federal system, the federal system favors release. And the United States Probation Office does a complete report, a risk assessment report on the person, if the attorney and the person choose to have that report done. And that's looking at your finances, where you live, who you live with, do you have any recent new arrests, do you have your criminal history in general, and then your criminal history as it pertains to violence or to acts that are violent or dangerous for the community, your employment, your family, gang affiliation. I've had a client be held accountable for gang affiliation he had 20 years ago, and he's a 50-year-old stay-at-home dad now, and they brought that up and used that against him. It's not in the same neighborhood. I mean, kind of a completely socioeconomically opposite neighborhood of where he was when he was 19 and 20 years old, but they brought that up. And then, for some people, they're looking at your immigration status. If we release you, are you just going to get put on your immigration hold with ICE and not be released anyway? So there's a lot of things that go into that. Ultimately citing danger to the community and flight risk as the reasons for detention. It's actually kind of I don't know. It's a favorable system here at the federal level, because if the judge does decide to release that person, they have the reinforcement of the United States Probation Office, who is going to be watching that person like a hawk, placing conditions on them, and essentially they're doing a probationary period pre-trial and before they're ever even brought in for guilty plea or sentencing or trial. Trial or sentencing. And so many people don't like the conditions that they have to be on once they're out, but unfortunately, the federal judges rely heavily on those conditions versus letting people go just on their own recognizance or their own accountability. So it's kind of a double-edged sword here, because we have a decent chance at getting people released, but it's their survival of the conditions after that always stump us. And it's nearly impossible for people in certain socioeconomic backgrounds and situations to maintain and to sustain those conditions. It would be hard for me. It would be hard for many of the professionals in this building to maintain some of these conditions. And we're asking somebody who has potentially less education, less stability financially, less stability in all the areas that we've been talking about to sustain these conditions. And then we act really puzzled and mad at them whenever they don't. And that's my daily tear that drops, because it's just really frustrating. So I don't regret here at the federal system.
Setting folks up for failure.
The one thing I was going to add at the state level that's really frustrating. So everyone, like what Christina's saying, Francie and whatnot about the risk assessment, I couldn't echo more. What I am very frustrated about is this idea that judges and district attorneys, they don't really look at these cases as individuals. They don't really look at these cases with anything other than, okay, if I let this person out and they kill someone, this is on me. And so it's more of like a ego thing. It's not really individualized. We constantly see things like gang affiliation being thrown out there, but then when you question and you have defense counsel or you have diversion hub or team there to kind of push back on that, they really don't have much of a leg to stand on. And so that's a perfect example, gang affiliation, like Francie is saying, from decades ago, but it's used in a fear-mongering way to get the judge to not even consider something that is that is reasonable. And so I definitely had to say that, because I think that's a big concern. District attorneys are looking for things to put in their file to justify why they're letting someone out, even though they don't pose a risk to public safety. The risk assessment, if you asked the judiciary, I guarantee a majority of them would say that the risk assessment really looks at quantifying the level of risk to reoffend. And so, Christina, thank you for bringing that up, because that's so frustrating. We know that this is going to have a disproportionate impact on minority communities, lower socioeconomic communities, because again, exactly what Francie's saying, if a court orders a slew of conditions for someone to complete in order to remain in the community, but yet their barriers to accessing those services aren't even addressed, we're really just keeping people in this cycle. And so I just had to echo kind of and build a little bit more on that, because it is something we're seeing every day.
Yeah, thank you so much. Cameron, I'm going to shift back to you. So I've often heard you say, and this is what the Bell Project says, cash bail is unconstitutional. Explain that to us. How is that unconstitutional? Why do we still have it in Oklahoma? And who is arguing for it, in favor of keeping it?
Yeah, I appreciate this question, because it's, cash bail being unconstitutional is a really loaded sentence in and of itself, because there's a lot of contextual law that goes into that statement. And I definitely defer to the attorneys to talk through that. there's typically kind of like two different arguments that are made around the constitutionality of bail. And in our case, the Bail Project, the unconstitutionality of bail. They can be rooted in the Sixth Amendment. They can be rooted in the 14th, in large part. And I usually defer more towards the 14th Amendment, because one of the things the 14th Amendment guarantees is that the state should not deprive any person of life, liberty, or property without due process of law. And again, we're talking about folks in the pretrial context that have not been convicted of the offense that they're being allegedly accused of, right? And so the importance of that is the question: why do we continue to detain and make legally innocent people sit in jail? Right. I think we can all agree that if you have, I think even wherever you sit at on the political spectrum, I think folks generally agree you should not be in jail if you are innocent. And because of that, we have to continue asking ourselves, well, if we know and the Constitution says that these folks are legally innocent, why do we continue to detain them? And so that sparks a lot of different controversy, a lot of different questions. So I'm going to stay away from like getting into the law too much, because it's not my area of expertise. But I think it's really important to frame it up that way, to be able to talk about the reality of the situation, which again, legally innocent people are in jail and they should not be. And the presumption of release should actually be the norm here in Oklahoma and in America generally.
Thank you. I appreciate that. So we know there's the bail bondsman. Why then? I mean, like, who's arguing or, to keep the cash bail system? Because Francie, I think you mentioned at the federal level that doesn't exist, right? And so why do we still have it in Oklahoma? Who's arguing for it?
There are jobs at stake and money to be made, and people's entire professions and livelihood are built on the idea of being a desperate person's only access to freedom in that moment. And if it was your business, you would be fighting tooth and nail and calling state legislators and trying to keep that bag secure.
Yeah. Exactly what Christina, I don't feel like we can ever have a true, genuine conversation about reform in the criminal legal system without realizing the profitization that we have across the board. We have for-profit supervision. We have for-profit, bail that industry is worth hundreds of millions of dollars. And so, of course, like Christina said, we're not really going to be able to look at the facts and understand that it's not working without realizing that these folks are profiting millions of dollars annually. So yeah, that's a huge piece of it.
Yeah, thank you. Any other folks want to chime in before I move to the next question? So I appreciate that being brought up. I want to talk about briefly before, because we're almost at time, but how all this whole system impacts our jails and the conditions in it. Someone help us understand what about the conditions of the jails and how, our system is happening, making it what it is.
Well, I'll say quickly that it's just it's a repetitive door. It's a repetitive cycle. Everything we talked about just keeps the jails overcrowded, overpopulated, for the simple fact that most people can't get a bail. And if they can't afford it. If they do get a bail, they're on all these stipulations. We don't even talk about how when someone said they take your license and then they put you on these systems that will let you out, but they don't keep in mind if someone's taking your license and you don't really have anyone in your family to help you get there, how are you getting to court? How are you getting to your attorney when you have these meetings? And then if you do take the chance of getting in your car and driving without a license, then you automatically reoffend. You end up right back in county jail. And then I'll say this too, I know a lot of guys that end up in jail with their kids because they're not at home to teach them how to not reoffend. So it's just a repetitive cycle on, and they're not able to stay clean because they don't give us enough cleaning supplies to keep the jails clean. They don't have any janitors to clean the jails themselves. So they kind of really rely on the inmates to keep it clean, but not give them the right supplies. And then the ones who are willing to clean, they don't have money on their books to get hygiene and stuff like that. So, and the hygiene stuff they do give you in jail is not worth a cent. So, it's those things.
Thank you,
Jail is meant to
Ryan.
humiliate. Jail is meant to humiliate and make someone feel less than human. And there's no sense of obligation or duty in the day-to-day experiences. You may have jail administrators and sheriffs talk about that at a very high level, at the need to the obligation to protect the lives and the humanity of the people that are in their custody. But every part of the experience is designed to humiliate.
And then once you're in those conditions and they continuously see you in those conditions, they start to look at you like an animal inmate. You don't have a name, or they want you to give your DOC number. It just becomes second nature. So, for them, it's natural for animals to live in a dirty, messed up conditions. So she's correct about that.
Yeah. And if you're coming from jail into your trial and you've been in those conditions, we know that the likelihood of you getting a conviction is increased, right?
Trial is also one of the few places where they actually, because it's so well litigated, that you can have access to clothing, to like your own clothing and that sort of thing. But whether or not you're handcuffed and all of that stuff. But what people forget is that all of those pretrial hearings, this, talking about the speedy trial process or the pretrial process, they're open to the public, and people are brought in slippers, chain cuffs, connected to other people, and in basically really uncomfortable pajamas in bright orange.
Mm-hmm.
And all of somebody's energy in that moment has to be focused, if at all possible, at preserving their own sense of dignity, much less participating in their own defense, understanding what's happening to them, making conscious choices when two bad options are the two options they have to pick from in the moment. The importance of having freedom while you are trying to make those choices cannot be understated. And all of the things that we associate with being incarcerated exploit those problems and make them worse.
Thank you for that. Well, so we've shared a lot of the problems and what's going on in the system. What can everyday Oklahomans do to help improve the system? Somebody, like me, who I'm not a lawyer. I don't, maybe necessarily work in this area. What can I do to, help improve it?
I'll say this: just keep having these conversations, keep thinking forwardly, and just keep speaking up about how unfair the system is, because that surely gives a person like me faith in the system again, which I've never had. Not that I have faith in the system now, but I know there's people out there that understand and that do want things to be better. So just continue to have these conversations and try to keep it in a positive light will go a long ways, if you ask me.
Thank you, Ryan. Anyone else?
I want to encourage people to be careful about what you're consuming about the criminal legal system in the media. There are local news anchors who will, pull a police report and a mugshot off the jail website and create a story. And all of that undermines, as much as anything else we've talked about today, the presumption of innocence. And so even if our client is able to get out of jail, get back to their families, they're now walking through a community who all saw them on the news without any additional extra context for what is going on. And so whenever you see a perp walk, whenever you see somebody in handcuffs, whenever you hear that somebody was arrested, please remember that that's the beginning of the process, and that the story is almost inevitably much more complicated and probably not nearly as terrible as what you've just been served up.
Yeah, that's a really important point. Thank you for that. Megan, did you have something?
I was just going to say, continuing to have these conversations, essential. Also, just trying to get folks to understand this is everyone's, it's a community problem. Just because you haven't spent a night in the Oklahoma County Jail doesn't mean that you should not be part of the solution to improve these failing systems. I think the community lacks a lot of empathy because we do have a lot of fear mongering, a lot of pushing, like Christina said, in the media, stories, posting mugshots. Those things are not helping preserve the innocence, but also they're detrimental to the community coming together and realizing that this is a community problem. We should all be working together. So just, I hear that constantly. And I think until people are directly or involved, whether it be a family member or a friend, they don't really think it warrants their attention. And I think that is what slows a lot of progress.
Absolutely. Thank you, Megan. Cameron, here.
Just real quickly, while we're having this conversation right now, the reality of the situation is there's thousands of community members that are legally innocent in jail right now. And, one of the things I wanted to kind of just drive home when we think about, at least here at the Bell Project, when we think about our data, when we look at it, we understand that nearly 1/3 of all of our clients go on to have their case dismissed. And this is happening, right, even before there's an opportunity to determine whether someone is guilty or not guilty, right? We're talking about before the trial phase, and we know those numbers continue to climb even higher, even though there's few amounts of cases that are actually being able to make it to that because of the fact folks are having to plead to get out and take care of their kids, to go back to work, to support their family, to do the best that they can to hold the pieces together. And so how an everyday person can be involved in that, again, I think it was perfect what Christina and Megan have already shared on that, but just like not forgetting that these are community members, and the vast majority of folks, they're going to be out, whether it's a day from now, a week from now, or maybe even 10 years from now, unfortunately, that they're going to be back and they're going to be a community member. They're going to be working alongside us. And it's really important to remember that we're talking about human beings whenever we talk about folks that are being incarcerated in a pretrial context, and we're talking about legally innocent people at that.
Thank you. I appreciate that. These are our community members, right? Francie, do you have any last departing words?
Yeah, I was listening to Ryan. I mean, obviously listening to everybody, but I think for me, your question, Evita, is like, what can we do, whether we're not attorneys or what an everyday community member is like. I kind of turn the question back on community members. What can you do? What is your lane? What's your talent? What's your gift? What can you use to have somebody like Ryan's back when he's not there? You're in a space and people are talking crap about the criminal legal system or the people who are accused, people who are convicted. Like, what are you doing to stand up for them? What are you doing to help them? And if it's something you're interested in doing, obviously, but some of us can be accountants and help a nonprofit look over their books, a nonprofit who's working in this work. Some of us can knit sweaters for children of incarcerated parents. Some of us can get in the courtrooms. Some of us can put our fist up and march in the streets. It's like, what is your thing that you do well, or that you're willing to offer towards the movement? And I would encourage people to pick that up and do it. We've got great people who are writers and can write great pieces that are creative. Maybe you can write legislative material and submit it to Oklahomans for Criminal Justice Reform to consider. Like, just find what it is that you want to contribute to people who are impacted by this and do that. And that is literally it. And that's people young and old, people of all backgrounds. I mean, we all can do something. My son is 10 years old, but I make him write letters to the people who are incarcerated because he needs to work on his handwriting. And also he needs to show love to people who are, in different situations than he's in. And I help him understand that. But that's also my gift to the community, is teaching my son to be somebody who is aware of these issues and practicing love for his community members in that way. So that's my 2 cents.
I love it. It's the beloved community. I am my brother's keeper. We are all responsible for each other, right? And to help each other when we fall down and to lift each other up. Thank you so much. That concludes our discussion for today. I want to say thank you to our panel. You all are awesome. You're doing awesome work in our community. To those that are viewing, if you want to learn more about this issue, which I strongly encourage you do, and not just learn, but get involved, just like they've been saying, you can find out ways to do that. You can visit our webpage at okjusticereform.org. You can also visit the sites of our panelists. There is a wealth of knowledge there. Still She Rises can be found at www.stillsherises.org. You can connect with the Bell Project at bellproject.org, the Diversion Hub at diversionhub.org, and you can also get a tour at the Diversion Hub as well. There are resources on the Federal Public Defender site at okw.fd.org. Again, thank you to all of you all for sharing, and thank you for tuning in. Have a great rest of your day. Bye.